Hello, everyone. For the folks joining, we'll get started in about 30 seconds or a minute. All right, in the interest of time, we can go ahead and get started. Good afternoon, everyone, and welcome to ELI's fifth summer school session this year, Basics of the Clean Air Act. My name is Madison Calhoun. I'm the Senior Manager of Educational Programs at the Environmental Law Institute. Each summer, ELI convenes a complimentary seminar series that offers an introduction to the legal and policy foundations of environmental protection in the United States. The series is aimed at folks who do not already have a background in environmental law. It's an introductory course into the basics and foundational elements of environmental law. So no matter your background, you're welcome to attend all of our sessions. We will have a session of summer school every week throughout the remainder of July from 12 p.m. to 2 p.m. Eastern, same times we're here right now. We will have one more session of summer school this year that will be hosted at our Washington, D.C. office at ELI. That's the Hazardous Waste Insights session at the very end of July. The other sessions will only be offered via webinar. All sessions will be recorded and posted to ELI's website within a few business days of each event. If you've missed any previous sessions that took place throughout June, we encourage you to check them out now via our website. You can find each individual session on our website at eli.org. Please reach out to me or events@eli.org with any questions. Now we'll go ahead and kick things off for today's session. Today's session, like I said, is an introduction into the basics of the Clean Air Act. In a moment, I'll hand things over to our wonderful moderator. She will give some opening remarks, and then our two panelists will each present. After their presentations, we'll have time for a roundtable discussion, followed by time to answer audience questions. Please feel free to submit your questions as soon as you think of them using Zoom's Q&A function. There's no need to wait until the end of the program. You can submit your questions as you think of them. The chat function is also open. We encourage you to use the chat to converse with one another or to post your observations throughout the program. However, please remember to put your questions in the Q&A box, not in the chat. And with that, let's begin. I'm now going to introduce our moderator, Pam Giblin. Pam is a senior policy advisor at the Climate Leadership Council. She was previously a partner for 24 years at Baker Botts, where she led the firm's environmental practice group. She's practiced environmental law since 1970 and has extensive experience in advising clients on a broad array of environmental issues. Pam was president of the American College of Environmental Lawyers from 2014 through 2015. She previously served as a member of the Environmental Protection Agency's Clean Air Act Advisory Committee. Pam has received her BA with honors from the University of Texas and her JD from the University of Texas School of Law. Pam, I'll go ahead and hand things over to you. Thank you so much, everyone.
Well, I really appreciate the privilege of participating in this program. And our vision of what we want to accomplish today is to give you a foundational grounding about the Clean Air Act, how it all hangs together to help you understand how to solve problems under the Clean Air Act. So I always like to go back to the basics. I always told people when I was managing the environmental department at Baker Botts, start with the statute, then move to the regulations, and then finally to the policy documents, because you had people who sometimes wanted to immediately go to the sort of the geekier documents, and the statute always takes us back. If you could post the first slide, I did a very quick summary of the history of the Clean Air Act. And this is important because the Clean Air Act basically started in 1970. That was the iteration that created EPA and implemented many of the current requirements of the Act. Fascinatingly, that 1970 Act was 38 pages. It's almost like the US Constitution. When you read it, it's very elegantly worded and gives very basic direction to EPA. Among the things that it mandated that EPA do, which is sort of the anchor of the Clean Air Act, was to establish national ambient air quality standards. And later, Baron is going to talk in greater detail about that. But again, it was an exquisitely elegant statute, short, and created the true north of the Clean Air Act, which was that certain health-based standards had to be attained, those national ambient air quality standards. And one interesting thing about the national ambient air quality standards is that since 1970, there have only been 6 pollutants designated as NAQSs, National Ambient Air Quality Standards, which is fascinating. There has been discussion that if greenhouse gases are to be regulated under the Clean Air Act in more force, that perhaps there should be a NAQS, a National Ambient Air Quality Standard, for CO2 or any of the other greenhouse gases. But so far, we've had 6 since 1970, and 6 continue. And one of them is kind of a sort of an anomaly. It's carbon monoxide, not carbon dioxide, which of course carbon monoxide is an asphyxiant. It's not really sort of generally considered as an air pollutant, but it's been there since the beginning. No NAQSs have been deleted. They're supposed to be revised periodically, and sometimes they are. But the lead NAQS, for example, was not touched for, gosh, like 20 years. And so but it's very important to remember that that's sort of the cornerstone of what was mandated in the original 1970 Clean Air Act. I had the privilege of working with Leon Billings, who was the author of the Clean Air Act of 1970, and he also authored the Clean Water Act. He was the chief staffer for the Senate Environment and Public Works Committee, and Senator Muskie from Maine was the main senator in charge of that committee. And Leon was masterful. I want to give a plug to an interview that Scott Fulton, former president of ELI, did with Leon Billings before Leon passed away, where Leon goes through the history of the Clean Air Act from the inside, and what it took to get it enacted, and what were the fundamentals that he was trying to work on. But he was marvelous. The Clean Air Act amendments of 1977, which I actually worked on because the original 1970 Act did not have pre-construction permit requirements. And so it set these standards, and then EPA had to go enforce them after the fact. But you could build something without pre-construction review. Well, just as a side point, Texas, for example, had had a Clean Air Act since 1965, 5 years before the 70 amendments. And in 71, Texas added a pre-construction permit requirement to their Clean Air Act, first state in the country to do this. And so one day I get a call from Leon Billings, who had heard about the fact that we had put this into the Texas statute, and said, I want to do that to the federal statute. So I started working with him. The amendments were supposed to pass in 75, but that took another 2 years. So the Clean Air Act amendments of 1977 introduced for the first time the notion of pre-construction permit, that before you could break ground on a facility, you had to get approval. You had to demonstrate that you were going to meet all of the standards, not just the National Ambient Air Quality Standards, but whatever other standards had been enacted in the meantime. Again, these little anecdotes that Leon Billings would share, Texas's permit provisions did not have any minimum below which you did not have to get authorized in advance. He thought that was a little harsh, that it was going to be difficult to sell that to Congress. He said there has to be some threshold below which you're not a major source, you don't have to get pre-construction permit approval. So he was trying to figure out where that threshold should be. Well, Senator Muskie was, as I mentioned, from Maine. So Leon, I was in his office, and he picks up the phone and calls Myron Knudsen, who some of you may have heard of. He's legendary within EPA. He's just recently retired, but he was head of Region 1, which included Maine. And so Leon says, okay, Myron, what does the largest source emit in Maine? The largest source of air contaminants. And Myron said, gosh, maybe 50 tons. So Leon said, well, let's double it. So the 100-ton threshold that was put into the 77 amendments as the major source cutoff came from that. So it was it was fascinating to see how the sausage was being made. So anyway, and then finally, the Clean Air Act amendments of 1990. And it's significant that a statute that is as powerful as the Clean Air Act has only been amended, twice since 1970. And the Clean Air Act amendments of 1990, and Jay is going to touch on a lot of what was added by that series of amendments. It's about 900 pages of amendments. So 38-page initial statute, and it just grew and grew and grew. And the most significant thing in the Clean Air Act amendments of 1990 was the addition of what are called Title V permits, which it sets up a process for consolidation of all the requirements that apply to a facility so that they could be codified in one place in that one Title V permit enforceable by EPA. Because over time, the various requirements that a facility had to meet, as you might expect, grew in terms of number and complexity, and there was a lot of push to have that all codified in one. So that was a hallmark. Next slide, please, and I'll go real quickly through this because our two wonderful panelists are going to cover this stuff in a lot more detail. This just shows the various titles, excuse me, of the Clean Air Act, and as I mentioned, Title I, in my opinion, is one of the cornerstones. It's the true north, the establishment of the national primary and secondary ambient air quality standards. And then the PSD, the prevention of significant deterioration of air quality, and all of that, which came later as the pre-construction permit requirements. And then you've got other titles. And again, Varun is going to talk about the mobile source piece of it, which is very significant. And then last slide, please. This again just summarizes the various programs. So under those titles, these are the programs that EPA has established and is implementing with the states. And one significant point about the national primary and secondary ambient air quality standards, while EPA sets them and revises them from time to time, it's the states that have to develop what are called state implementation plans to demonstrate how they are going to attain and maintain those standards within all of the states. So there's a significant role that was set out in the 70 amendments for states. EPA supervises those, reviews the state implementation plans, but the states have the primary responsibility to choose the mix of controls and reductions that would attain and maintain those standards. Okay, now let me introduce our wonderful panel because I think we're very fortunate to have people that work in this every day. So Varun Shekhar is a partner at Babs Calland, and he has a very broad portfolio. He works in the environmental and transportation safety group at the firm, and he also works in the intellectual property practice. So he has a technical background. He got a degree, an MS in biomedical engineering. So he has the technical and the legal. He received his law degree from the University of Wisconsin Law School, cum laude. And as I mentioned, he works a lot in pretty much all aspects of the Clean Air Act. And then we're also very fortunate to have Jay Duffy, who is with the Clean Air Task Force. And Jay, his work right now is focused on greenhouse gas pollution at power plants. So one of the, again, I'm so biased in favor of the Clean Air Act in terms of what an elastic statute it is. The ability to regulate greenhouse gas emissions without a specific federal statute dealing with that, I knew was going to come through the Clean Air Act because the Clean Air Act has all that flexibility. And so Jay is going to fill us in on that. He has a JD from Villanova Law School, where he was associate editor of the Environmental Law Journal. And again, he has a lot of real world expertise that he's going to share with us. So with no further ado, Varun, take it away.
Oh, you're muted, I think, Varun.
some reason my mute button went away. I don't know what happened to it, but thanks, Pam, for that great introduction. I just want to make sure. There we go. Madison, can you hear me?
Yes, we can hear you now. You're good.
Great. Thanks. Not sure what happened, but again, thanks, Pam, for that great introduction. Again, my name is Varun Shakar. I'm going to be providing an overview of some of the major provisions of the Clean Air Act. Particularly, I'm going to focus on stationary sources and mobile sources and what regulations pertain to them. So we're focusing mainly on Title I and Title II. Also, there's some, Title V, for example, which also has a lot of kind of impacts on stationary sources as well. So to start, I wanted to go over some aspects of the scope of the Clean Air Act. Am I not able to? There we go. Okay, perfect. So I just wanted to start with some kind of preliminary scoping concepts with respect to the Clean Air Act. And before I get into that, I just want to kind of underscore what Pam was saying about the kind of the comprehensiveness of the Clean Air Act. And it, in my opinion, is one of the most complicated statutes out there in kind of the environmental arena. But that said, it's also arguably one of the most important. Probably the preeminent environmental sort of issue that we're facing these days is climate change. And as Pam mentioned, it's one of the main tools, at least on the domestic front, to attempt to regulate in that area. And so, it's a very complicated statute, and there are practitioners, including Pam, who have dealt with this for decades. And even that being so, you kind of learn something new every day about the Clean Air Act. And it's just, it can be very dense at times, but it's important to kind of understand some of its nuances. And I think that I'm not going to purport to be able to, cover all of it in 30 minutes. So I'm just going to touch on some of the high points, but I wanted to start with what exactly is covered under the Clean Air Act, and then how does the Clean Air Act go about in regulating those aspects. So when we're starting to talk about the scope, you have to start with air pollutants, which is kind of the basic unit of what's regulated under the Clean Air Act. And I put the definition here from the statute. And whenever I read it, I find it to be comically broad. Any physical, chemical, biological, radioactive substance or matter which is emitted into or otherwise enters the ambient air. Congress, for all intents and purposes, could have just basically replaced the first 4 lines of that or 3 lines of that with anything. It is so broad. It certainly encompasses things like greenhouse gases, carbon dioxide, among other things. Now, when we're talking about some of the programs that Pam summarized, there's going to be some sort of a showing of health impacts or environmental impacts that will kind of narrow down what exactly the scope of air pollutants is. But it is a very broad definition. One limitation on it is in the last part of it, which is the emitted into or otherwise enters the ambient air. That's an important limitation to kind of make it clear that when we're talking about the Clean Air Act, we're not talking about indoor air quality. That is something that is more, for example, with respect to OSHA. There may be some other standards as well, but the Clean Air Act is focused on emissions to the outdoor air. As far as the units that are regulated, there's a couple flavors of them. Stationary sources, which is Title I, as Pam mentioned. I have the definition there again. It's basically defined as anything which is not mobile sources, internal combustion engines for transportation purposes. So think of things like factories. It can even be things like a pile of coal that sits on a facility grounds. Fugitive emissions that come from that. Those can be stationary sources. Mobile sources, we're talking about things like motor vehicles, which is kind of self-explanatory. And then also a category called non-road engines. Think of things like cranes, tractors, things that don't travel on public roads, but they're kind of mobile, and they have engines that emit into the atmosphere. So those are the base, kind of an overview of the units that are regulated under the portions of the Clean Air Act that I was talking about. So we've identified air pollutants. We've defined the scope of them. How does the Clean Air Act actually regulate that? Well, there's a couple ways they do it. As Pam alluded to, we have the National Ambient Air Quality Standards, or as air practitioners call them, the NACs. And the Clean Air Act requires EPA to establish the NACs for certain air pollutants, namely those which, when they're emitted, cause or contribute to air pollution, which may reasonably be anticipated to endanger public health or welfare, and which are also present in the ambient air due to stationary or mobile sources. As Pam mentioned, there's been NACs established for 6 pollutants, basically from the 1970 Clean Air Act. These are called criteria pollutants. And the 6 are listed here: sulfur dioxide, carbon monoxide, ozone, particulate matter, and this includes both coarse and fine species, as well as nitrogen dioxide and lead. An important add-on to that is, although these are the 6 criteria pollutants, it also includes the precursors to those pollutants as well. So for example, if we're talking about ozone, ground level ozone at least, 2 important precursors of that would be volatile organic compounds, or VOCs, as well as nitrogen oxides, which are a very common emission from engines and most combustion sources as well. So although this list is limited to 6 for NACs, it can be broader than that, given what sort of precursors are involved in the formation of these pollutants. In addition, as Pam mentioned, NACs come in 2 flavors. We have primary NACs and secondary NACs. The primary NACs are designed to protect public health. The secondary is more for kind of environmental. When we're talking about things like decreased visibility, damage to crops or vegetation, those are more of secondary NACs. Now, as far as what the NACs look like, they're a concentration threshold. So we're talking about parts per million, parts per billion, sometimes it's micrograms per meter cubed. And I'm going to show what the current NACs are in a minute. But an important point to make here is that the NACs aren't directly applicable to individual sources. Rather, they are kind of nationwide air quality standards that EPA has set, but states have the onus on being able to attain them as far as the ambient air within its borders. So here is a table of the current NACs. As Pam mentioned, some have been revised less often than others. Ozone, SO2 have been kind of the more recent revised ones. And a couple things to point out here. So we have the list of criteria pollutants on the left, the 6. We have an averaging time, which is the 3rd column from the left. So the important thing to point out there is NACs can sometimes be designed for, at least when we're talking about, for example, primary NACs, designed for acute health effects as well as chronic exposure health effects. And so that's why some of these NACs have a shorter term averaging time. So for example, ozone has both. We have an 8-hour averaging time standard as well as a 1-year NACs or annual NACs. The other thing I want to point out is on the rightmost column. And the important thing with that is, as I'll talk about in a second, attainment of the NACs is predominantly determined through a network of ambient air quality monitors that we have installed nationwide. And a recording in one of those monitors that is over the NACs numeric limits here doesn't necessarily mean that you've exceeded the NACs or that you have non-attainment with the NACs. There's statistical analysis that has to go into that based on a totality of data that's recorded by the monitors. And so that's another important limitation to keep in mind when we're talking about attainment or non-attainment with NACs. As Pam mentioned, NACs are reviewed periodically. They're you're supposed to do, under statute, EPA is supposed to do it on 5-year intervals. In practice, that doesn't always happen. And sometimes the NACs, even if they're supposed to be, if there's a reason for them to be revised, EPA doesn't get around to revising them until much later. Sometimes there's litigation that ensues because EPA is kind of dragging its feet, or a variety of reasons. As I mentioned, all areas of the US will either be designated as attainment or non-attainment with each of the NACs. There's also a third category, unclassifiable, which is kind of self-explanatory. If there's not enough data to kind of support one of those designations, it goes into that category, but essentially it's treated as attainment. What those mean are kind of self-explanatory. Attainment means that the area's ambient air is at or below the applicable NACs. Non-attainment means they exceeds the NACs. And you can have attainment or non-attainment on a pollutant-specific basis. So if an area has a relatively low concentration of ozone, for example, within its ambient air, but has a very high concentration of sulfur dioxide, that area might be in attainment for ozone, but non-attainment for SO2. So it's on a pollutant-specific basis. And as I mentioned a second ago, the designation of attainment or non-attainment is based principally on data that is recorded through a network of ambient air quality monitors. Sometimes the siting of monitors is an issue that comes up, and there's kind of debates over it. Certainly, if you have a big source, stationary source that emits, a lot of a certain pollutant or certain other pollutants, you want the monitors to be able to pick that up so that you're accurately characterizing what the ambient air quality is. But it can be tricky sometimes. Weather patterns might change, or that they're kind of variable. Topography can make it difficult to figure out where's the best place to site that. And obviously the universe of sources can change too. Sources open up or newly constructed. Sometimes they relocate or close. And so what that monitoring network looks like is a very dynamic sort of process. So here's a map of the current non-attainment areas in the United States. Key areas I'll point out: California. You can see kind of in the southern central California area, you have counties which are designated as non-attainment for all 6 NACs pollutants. California is kind of infamous in that respect for its air quality, but it's not completely due to a massive amount of industry or lots of mobile source pollution. California has kind of a unique geography. There are a lot of valleys kind of dotted throughout, and this can kind of trap some of the pollutants in the ambient air. There's also unique weather patterns. You have things like inversions. So, although those areas that are kind of shaded, pink and yellow there are kind of isolated to California, there's a number of reasons for that beyond just the universe of sources out there. So we just talked about the NACs, and I mentioned the NACs aren't directly made applicable to the sources. How do they eventually apply to sources? Well, it's through state implementation plans, or SIPs. As Pam mentioned, SIPs were kind of born out of the purpose of the Clean Air Act, or one of the purposes of the Clean Air Act, which is to instill this notion of cooperative federalism, which is a principle that is also present in other environmental statutes. But essentially, it relates to kind of these dual purposes. One being a recognition by Congress that states and local governments are to be the key agents to control air pollution, but at the same time, Congress also recognized that the federal government has an important role to play from a policy development standpoint and in driving, the sort of standards at a nationwide level. And so the compromise that came out of that is this state implementation plan framework. And what it involves is states have some leverage or some latitude rather in designing what sort of control strategies that it would undertake to achieve the NAAQS within its territory. So there's, as I said, a lot of latitude. It could be in the form of emission standards. It can be in the form of work practice standards. There are a variety of tools that states can use to put into its state implementation plan. But ultimately, what all SIPs have to contain would be some sort of a control strategy. It has to have a schedule for attaining the NAAQS and a plan to maintain the NAAQS as well. And then finally, there has to be a technical demonstration that the control strategy or strategies that are chosen will actually lead to attainment and maintenance of the NAAQS. That last part can be, it is a very highly technical demonstration. It often involves air quality modeling, which, and this is at a very kind of high level, but it involves characterizing the universe of sources, the amount of emissions and the type of emissions that come from those sources, factoring in kind of a spatial aspect, the geography aspect, and weather patterns, and then using all of that and basically implementing it in a computer program. And then with that, you'll get an output which will say, well, here's what the ambient air quality is predicted to be based on all those inputs. So all of that goes into the SIP, and the SIP is then submitted to EPA by the state, and EPA can either approve or disapprove those SIPs. If there isn't a satisfactory SIP, EPA has the authority under the Clean Air Act to put in a federal implementation plan for that area. And states never want FIPs because they're losing their authority to regulate the sources within its own state. So states usually are able to get an approved SIP. FIPs can also be imposed not entirely over the scope of the SIP, but also in part if there's certain aspects of the SIP that EPA finds unacceptable and the state isn't able to remedy that, you can have partial FIPs that just cover that area. There's also other punitive measures that are imposed if a state doesn't properly submit a SIP. Can be things like loss of highway funding, and there's other sort of offset controls that are imposed on them. So states generally try to avoid all that. Now there was a question I saw, a bunch of questions here. Let's pause here and go through some of these questions. I see one question. New Jersey is very clustered with 2 NAAQS pollutants. Can you speak to that a bit? What does that mean for the state, high level? Let's go back to the map here. So I know I'd have to look up to see what exactly they're non-attainment for. I believe one of them is for ozone. New Jersey is also in an area called the Ozone Transport Region, which is a kind of a bunch of states in the Northeast. And they're kind of treated as non-attainment for ozone for all intents and purposes. And as far as what does that mean for the state, I'm going to talk about that a little bit later, but if you're in a non-attainment area and a source wants to construct if a company wants to construct a source there, that could be a little bit more onerous as far as what sort of permitting might apply. There's other sorts of controls that apply as well. On the mobile source side, there might be evaporative fuel standards that are implemented there. I'll talk about that a little bit more as to what happens if you're in a non-attainment area and what are the implications for sources within. I got another question. What happens when Canada, with wildfires and air quality effects, our states? So international air pollution, there is a provision in the Clean Air Act that talks about it. I'm not going to really cover it in my section, but ultimately, a lot of that is covered through treaties. And as far as Canada goes, those do impact the NAAQS. So if you have the monitors, when we're talking about fires, we're predominantly talking about PM 2.5 is the main issue with that. And so those monitors were monitoring very high concentrations of PM, well above the NAAQS. So those are going to impact to some extent, or could impact kind of attainment designations, although in practice, EPA is going to look at the long-term averaging of that. If we go back to the PM standards, put back to that real quick, show this.
And let me
Yes.
just add that there is an exceptional events rule that's subject to a lot of litigation right now, so that wildfires, for example, either domestic or international, are not counted. And that's, like I said, subject to a lot of debate right now, but the exceptional events rule would also apply probably to Canadian wildfires.
Yep, and that's a regulatory provision that's why it's under a lot of debate, but that is certainly a provision that's going to be argued here, because otherwise states are going to have, at least the affected states are going to have a lot of non-attainment issues. Can you speak to why the greater New York City area is designated non-attainment? So I think one of them is ozone. I'd have to double check what the other pollutant is. Why is it non-attainment? Likely because of industrial impacts, various sources in the area. The other thing I want to point out on some of these non-attainment is you can have downwind impacts. And the Clean Air Act has a provision called the Good Neighbor provision, which requires EPA to regulate interstate transportation of air pollution. And so there's a rule that came out fairly recently called the Good Neighbor rule, and the FIP that was also imposed as part of that. And so, and I also mentioned earlier, a lot of these northeastern states are part of an area called the ozone transport region. And so my guess is that New York being in that location is probably impacted by some of that. What do you think is the best advice or information to give employees when giving an educational presentation about the Clean Air Act to a company? That's an interesting question to field. We'll come back to that, I think, maybe towards the end when we cover all of the Clean Air Act provisions. What's the status of the EPA's proposed revisions to the PM 2.5 standards? So I think I'm going to talk about PM 2.5 a little bit later. We'll come back to that as well. Mobile source or engine is operated in a building at a stationary source. Are the emissions considered mobile source emissions, or are those considered part of the stationary source? So what I gather is, let's say you have a tractor or something, a forklift that is in a building. Are those emissions mobile source? So the engine that is part of that vehicle would be regulated most likely under Title II. If it qualifies as probably be a non-road engine at that point. As far as emissions that come from the vehicle into the source and then from the source to the ambient air, it kind of depends what emissions we're talking about. If we're talking about things like volatile organic compounds, EPA has pretty detailed guidance as to when something that goes into the inner space of a building, but might be exhausted out of the building through a window or the exhaust system, when does it count as emissions to the ambient air? Again, it depends on the pollutant. If we're talking about something like VOC, if that building has an exhaust system that basically collects it and just pumps it out to the ambient air without any sort of control of it or destruction of that, that might be considered emissions from the stationary source. If it's something like PM that doesn't really exit the building, or if it just kind of stays trapped inside without much emissions coming from it, it arguably would be not considered regulated under the Clean Air Act. All right, let's pick up again. Where was I? So we talked about SIPs. So SIPs are one route to regulate air pollutants. Another way that regulation occurs is through new source performance standards. And these are federally imposed standards and promulgated standards that are for new, modified, and reconstructed sources that are in certain source categories. And those source categories will be determined by EPA to cause or contribute significantly to air pollution, which may reasonably be anticipated to endanger public health. So there's a number of source categories out there, and these performance standards are specific to sources that are in those categories. the standards that are imposed under the NSPS program are required to reflect the best system of emission reduction, sometimes short for BSER. This was an issue that came up in the power plant carbon dioxide litigation, West Virginia versus EPA, considered standards that were for existing sources, which I'm going to talk about actually in the third bullet, but the best system of emission reduction was a key element of that. Does that entail, what does that entail? Is it a control device? That could be a best system of emission reduction. Is it something which is more industry-wide? Is it, for instance, shifting the sources of power generation away from, for example, coal-fired power plants over to renewables or natural gas-fired power plants? That's an issue that Jay will talk about a little bit more in the West Virginia case. And then, as I said, we're talking about new, modified, reconstructed sources. There's a parallel section in this portion of the statute which requires EPA to establish similar regulations on existing sources under those source categories. The standards wouldn't be, a numeric standard that applies to the source directly as it would for new sources. Rather, the way that those are regulated would be through a state plan. It's not a SIP, but it's a state plan that might be incorporated into the SIP, but it's a state plan where the state would have latitude to develop some sort of policy or control strategies that would achieve the existing source performance standards under that provision. Another aspect to regulation of air pollutants is for hazardous air pollutants or air toxics. The Clean Air Act had provisions on this, but they were really ramped up in the 1990 amendments. And when we're talking about hazardous air pollutants or HAPs, we're talking about, there's a long list of them, but the ones that kind of come to mind first are the BTEX constituents: benzene, toluene, ethylbenzene, xylene. These standards can be both technology-based as well as risk-based. The technology-based standards are also sometimes called MAX standards, maximum achievable control technology, achievable control technology, and they are based on control technology that reflects the maximum degree of reduction in emissions. How does that's achievable? How does EPA determine that? There's a statistical analysis to it. For new sources, they would look at the best controlled similar source, and they see what sort of controls are in effect there. Whatever emission rate is being achieved through that becomes the MAC standard for new sources. For existing sources, the MAC is determined through the average of the best performing 12% of the universe of existing similar sources. So those are the technology-based standards, but there's also a second component to it. Those are risk-based standards. So every 8 years, EPA is supposed to do a review of the adequacy of the MAC standards. And if there's deemed to be a residual risk to public health in those, from those standards, if they're not adequate enough, EPA can impose what's called a risk-based standard. And the risk-based standard is based on kind of these health endpoints, and they're set where it allows for an ample margin of safety. So you'll have a certain, for example, carcinogenicity risk, and EPA will consider that. They'll have a certain margin of safety that they seek to implement, and then out of that comes a numeric standard that's applied. These are for certain sources. Another alternative term for them are NESHAPs, National Emission Standards for Hazardous Air Pollutants. And there's a couple questions I see here on this. Where are we? I think there was a question. I kind of lost my place, but I think there was a question as to how do hazardous air pollutants or the NESHAPs mesh with the NACs. So they're separate. The NACs are for the criteria pollutants. Criteria pollutants, none of them are HAPs. HAPs are separate from that. And the NACs, as I mentioned earlier, how do we achieve the NACs? There's a variety of ways you do it. The state implementation plans, that's kind of the key tool in achieving or attaining the NACs. But the NACs are separate from these standards. They're completely different statutory provisions and they address different pollutants altogether. All right, so I'm going to move on to permitting. Pam mentioned pre-construction permitting. This was a mechanism that was added to the 1977 Clean Air Act amendments. And there's two parts of it. You can have a pre-construction permitting for areas that are in attainment areas, and you can have a parallel pre-construction permitting framework for areas that are in non-attainment areas. And there's a couple different levels to this. There's what is sometimes called by practitioners as minor new source review, and there's something called major new source review. The Clean Air Act provisions pertain predominantly to major new source review. What is major new source review? Well, it applies to sources that are classified as a major source. And when they make a major modification or if it's newly constructed or reconstructed. So you have a major source or a major emitting facility if it exceeds a certain emissions threshold. What that threshold is dependent on the source, the source category. Certain source categories, it's a lower threshold of 100 tons per year of a regulated NSR pollutant. The regulated NSR pollutant can be broader than your criteria pollutants, but in general, there's a lot of overlap between them. For all other sources, sources in other categories, it's 250 tons per year. So that's the major source aspect of it. Now there's a major modification if we're talking about, certainly if it's a newly constructed or reconstructed major source, that will trigger a major NSR permitting. The modification is a little bit trickier. You need to rise to the level of a major modification. And how do you determine that? There's an emissions threshold, increase threshold that you would have to determine in order to find whether or not you've triggered this major NSR permitting. The minor new source review is largely a creature of a state implementation plan. So if you have a source that doesn't meet the criteria I was just talking about, a major source or a major emitting facility or doing a major modification, states will still have their own pre-construction permitting requirements for that. And those are called minor new source review. Those vary across the board, but in general, there's a requirement to apply for a permit before the construction takes place or the modification takes place. So I mentioned there's two kind of avenues for attainment areas. There's a new source review permitting that is called prevention of significant deterioration, or PSD for short. The PSD permitting, as I said, is pre-construction, and it applies to construction or reconstruction of a major source and also a major modification. With respect to what's a modification, there are certain exclusions to that. The big one I'll highlight is something called routine maintenance, repair, and replacement activities, or RMRR. There's been a lot of litigation and fights over what that means. If let's say you have a factory and you're replacing, a widget, or you're changing the color of it, is that a modification? Modification is defined as pretty broadly as any physical change or change in the method of operation of the source. So something like that arguably could be a physical change, but does it rise to the level of a non-excluded major modification? So routine maintenance, repair, replacement, there's a bunch of factors that go into it. Things like cost, the nature of the project. If it's something where it's going to take years and years, those are factors that are considered in determining, is that routine maintenance, repair, and replacement, or is it non-routine? If it's non-routine, it would count as a modification that you'd have to then go through determining, is it a major modification? With respect to determining a major modification, I mentioned there's a certain threshold of emissions increase that qualifies it. And we're talking there about for PSD purposes, there's a couple emissions tests. The test that most sources will use is called baseline emissions to projected actual emissions. Basically, you will look at a previous number of years on an annual basis, what were the average amount of emissions, and then you compare it to, okay, once I implement that change that I want to do, what are your projected actual emissions afterward? And you compare, you do a net analysis of that. And if that difference is more than a certain threshold for that pollutant that's impacted by the change, then you would they would constitute a major modification and a significant emissions increase. That threshold is pollutant specific. It's 40 tons per year, for example, for sulfur dioxide. It's 25 tons for PM. So that's something that you'd have to kind of go through on a pollutant by pollutant specific basis. So I talked about how do you trigger PSD, but what's the significance of PSD? If you trigger PSD permitting and you have to get a pre-construction permit, the main things that apply are you have to do a detailed air quality analysis that's going to demonstrate you're not going to cause or exceed the exceedance of the NACs. There's also a related concept called a PSD increment, which is, even if your change is going to be within the NACs, there's a certain margin that you're sort of allowed. That's called a PSD increment, meaning to fall within that. The other big thing is the source would have to install best available control technology, or BACT. And this can be costly for sources. And that's why sources a lot of times try to structure their operations or their changes or projects so that it avoids triggering PSD. BACT is, I have the definition here, but it does take into account cost. It takes into account what's available out there in the industry. A lot of times there'll be a threshold, a cost per emissions reduction threshold. Does that qualify as BACT? To make this easier, sometimes EPA will point sources to something called a BACT clearinghouse. The BACT clearinghouse it's kind of a repository of what sources by category have used to implement as BACT. But those are the two big things. And as I said, those can be costly to a company. And so that's why a lot of times companies will try to avoid PSD and structure it in a way that does that. For non-attainment areas, there's a parallel permitting pathway, a pre-construction permitting framework. The key differences are, in general, there's going to be lower significance for emission increases thresholds. So, for example, for ozone, it's 40 tons per year. For PSD, it's 25 tons per year in general, and it can be lower depending on the degree of non-attainment we're talking about. In addition, I mentioned BACT for PSD. Well, BACT on steroids is something called lowest achievable emission rate, or LAIR, and that's even more stringent controls, less emphasis or consideration of costs, and more on what sort of technology is available. And so this can be even more costly than BACT. And the last thing is there's also a requirement for emission offsets. And so some states will, in some states, it's implemented through a trading program. You have things like emission reduction credits, where you'll have, for example, a facility shuts down, they've reduced their emissions or emissions to that state's air, there's some credits. So a lot of times there's an offset sort of framework, which is a trading aspect, there's a trading aspect to it, which is required under non-attainment new source review. All right, I'm going to try to speed things up a little bit here, but Title V permitting, Pam mentioned that, applies to stationary sources. The big thing with it is it constitutes kind of an integrated permit, or a permit containing all of the integrated requirements that apply to it. So this includes things from the SIP, it includes things from an NSPS or a MAC standard or NESHAP. And it's a one-stop shop that a covered facility can refer to say, okay, here's all the requirements that apply to my facility. In addition, the Title V permitting provisions require annual compliance certifications, as well as periodic deviation reporting. So this is important because sources have to basically do not so much an audit, but they have to take a tally of what sort of non-compliance is out there, and they go through their permit condition by condition. Am I in compliance with it, or am I not in compliance? And if they're not in compliance, they must report that to the agency. The Title V permitting framework applies to major sources, and note that this is different than the major emitting facility threshold in the NSR program. This applies, the major source for Title V purposes is if you have greater than 100 tons per year of a criteria pollutant, or over 10 tons per year for a single hazardous air pollutant, or 25 for all HAPs combined. So if you exceed those thresholds, you're part of the Title V permitting framework. You have to apply for a Title V operating permit. So it's not just pre-construction permitting, but operating permits. And again, the permits, the text of them are going to contain detailed limits or provisions on how you operate your facility. Just a couple closing thoughts in Title I. EPA has pretty broad authority to enter and inspect facilities. They have an investigatory avenue called information requests under Section 114. They can serve requests on facilities, and the facilities have to answer those. EPA can say, tell us about what are your emissions for this year or for this period. Tell us about the nature of your processes. And so they have very broad inspection abilities on that front, and a lot of tools that they have at their disposal. As far as enforcement goes, there's a few avenues that EPA can proceed under if there's alleged violations. EPA can file a civil lawsuit in conjunction or through DOJ, the Department of Justice, in federal court, and they can seek penalties, civil penalties. It can seek injunctive measures. So it could be something like, they get installed as control technology. That's an example of an injunctive measure. It can pursue in egregious cases criminal sanctions in federal court, again through DOJ. These are typically for willful or knowingly committed violations. And then finally, it can proceed administratively. So it doesn't have to actually go to court. It has the authority under the Clean Air Act to issue an order to pay penalties, civil penalties, or it can also issue an order for the facility to undertake, again, some of these injunctive measures. A lot of the times these are under consent. So, the EPA will issue a notice of violation or a finding of violation. The parties will confer, and then rather than deciding to go to litigation, they'll say, let's resolve this administratively, and these orders that will require these aspects are done through a consent, on a consent basis. There is a 5-year statute of limitations. This isn't in the Clean Air Act itself. It's in a more general statute on federal claims. But keep in mind that there are parallel paths to enforcement here. The state enforces its state laws. EPA enforces the SIP, which is incorporated into the federal law. And so, EPA, you could be subject to enforcement by EPA and or the states as well. And the states, when they're enforcing their own kind of state regulations, the statute of limitations is going to be longer than 5 years. It depends on the state. I'm very familiar with, for example, Pennsylvania. I do a lot of my work there. They have a 7-year statute of limitations. And then a last thing on enforcement is citizen suits. So enforcement doesn't have to only proceed through a public agency. Members of the public can also bring suit, and they can sue not only companies, but they can sue states or EPA for violations of the Clean Air Act. And the remedies that are available are similar to what's available to EPA. On the penalty aspect, I will note that if an entity is filing a citizen suit, they don't get the penalties themselves. That goes to the US Treasury. But there may be other avenues for them to recover. In some cases, they can recover attorney's fees, and there's a certain standard to get those. All right, real quick, because I'm running a little long, but real quick, I want to make a mention of Title II, which is mobile sources. Title I, which is stationary sources stuff, gets a lot more attention, but mobile source emissions are really significant when it comes to air quality. I have a couple graphs here. One is from New Jersey, and the green part of this pie chart is non-road mobile sources. The red part is general other on-road mobile sources, so things like cars and trucks, and that accounts for the majority of emissions of at least air toxics in this case to the ambient air. With respect to nitrogen oxides, which is a precursor to ozone, as I mentioned earlier, this is, I believe, from California in the bottom right pie chart, and the combination of the blue and the gray are mobile source emissions of NOx. So again, the majority of it is coming from mobile sources. So you can't truly appreciate air quality and how to solve issues with air quality without also regulating mobile sources as well.
Arun, I think this helps explain to some extent why New Jersey and California have so many exceedances in the national ambient air quality standard. A lot of it is mobile sources, and especially when they're idling and stalled, if they're not moving rapidly, as you know, that could exacerbate the problem. So I think that sort of sheds some light on the anomalies that people were seeing in those two states.
Absolutely. And California, well, especially Southern California, known for its high volume of vehicular traffic,
Right.
I think combined with its kind of valleys and its unique geography, they have very large contributions of to a non-attainment standpoint from mobile sources.
Yeah.
So I'm just going to kind of real quickly skim through this. I was hoping to get in a little bit more detail, but so when we're talking about regulation under Title II, it's a little bit different than Title I. I mentioned with Title I and stationary sources, this cooperative federalism approach. States are in many respects the driver of air pollution regulation. It's a little bit different on the mobile source side. EPA is, for mobile sources, the principal driver of standards. And the standards aren't imposed on the operators or the owners of the sources like they are on Title I for Title I. Rather, the standards predominantly apply to manufacturers of vehicle engines as well as manufacturers of fuels or additives. So, if you have a car and it's kind of, they're not performing as well as it should from an emission standpoint, yeah, you might have issues titling it or getting it, smogged with your DMV, but EPA is not going to come after you. That enforcement under Title II is mainly towards manufacturers. How does the regulatory process look like? Well, EPA and to some extent California, which we'll talk about in a second, establishes emission standards for mobile sources, and the engine manufacturer is responsible for performing emission testing on prototype vehicles or engines. And once it does the testing, it submits it to EPA, who will review it. Sometimes EPA does its own testing. And then EPA will issue a certificate of conformity with the emission standards upon application from the manufacturer. So each car out there, at least since the enactment of Title II, is supposed to have a certificate of conformity. There's limited exemptions, but in general, each engine needs to have a certificate of conformity. There are light duty vehicles and heavy duty vehicles. Light duty vehicles are kind of the passenger cars and trucks. There's a weight threshold that I have here. And the thing I'll point out here is there's been various iterations of standards. They're called tier standards, tier 1, tier 2, tier 3. We have new standards that have been proposed in April, which pertain to not only some of these kind of criteria like air pollutants. They're a little bit different on the Title II side, but for all intents and purposes, they kind of match up nicely. But there's also in the most recent proposed rule standards for greenhouse gases. They got this mainly from California, which they did at the state level. There's also standards for other things other than just these sort of criteria air pollutants. There's standards on evaporative emissions. You just park your car outside it's going to have some losses from the fuel, and those are emissions into the ambient air. And so there's standards on that for cars. There's other standards for onboard diagnostics. So if you have an engine or an emission control equipment in the engine that has failed, there's requirements for cars after certain years to have diagnostics that'll alert the user, hey, this is not working right, and so that it promotes getting those things fixed in a timely fashion. Similar standards for heavy duty vehicles, things like trucks and buses. And there's a hodgepodge of standards depending on the weight and the horsepower and nature of the engine. The testing aspect, as I mentioned, the manufacturers do a test. There's a certain protocol that they have to follow when doing the test. And this is important because if you test it at certain standards which aren't reflective of how the car is or the vehicle is normally driven or operated, you're going to not have a true representation of what those emissions actually look like. And from an air quality standpoint, that's obviously untenable. And so the thing to note here is there's a kind of a centralized federal test program that EPA promulgates. It revises it over the years, depending on driving habits. In the early years, it was a very kind of steady state sort of framework, which was not reflective. They've thrown in additional test cycles for aggressive driving, aggressive starts and stops. Also, various operational conditions like weather. And the other aspect of testing is that engines can age. And if you test it when it's brand new, you may not get the same result if you test it 3 years in. So EPA also requires manufacturers to test in-use vehicles after a certain number of years. I'll also mention at the end an enforcement case with VW, but Volkswagen, but you can't cheat the test. You can't put in devices that when you're testing it, you suppress emissions, and then when you're not testing, you remove it or stop operation of that control, and then you have a larger amount of emissions. Preemption, important part of Title II. The Clean Air Act generally preempts states from imposing their own emission standards on mobile sources. There is an avenue for a waiver from that, and California has it. California's waiver had to meet certain requirements. The 3 elements are up here at the top. They have to be at least as stringent as federal standards. They have to meet compelling and extraordinary conditions, and it also has to be consistent with the Clean Air Act as far as technical feasibility and lead times that are given to manufacturers as far as a compliance schedule goes. The waiver can be on a item specific basis. So, California has standards for the various sort of criteria pollutants, as I mentioned, but they also have standards on greenhouse gas. They initially got a waiver, but there's a back and forth about that. So ultimately, the EPA currently has reinstated their waiver for greenhouse gas standards. There's also a fuel component. Title II regulates the manufacture of fuels. Manufacturers have to register emissions of fuels when they are manufacturing a new one. And there's a lot of demonstration that goes into the registration process. There's a testing aspect. Is it performing as it should? There's a baseline fuel that serves as a reference. And then when you have a target fuel that's introduced to the market, they have to show that the performance is at least comparable or better. The other thing I'll make reference to is renewable fuels. This was enacted through 2005 legislation called the Energy Policy Act. And basically where we're at with that is the requirements for fuels sold in the United States, at least a certain percentage of them, to incorporate renewable components to it. And so, when you fill up, you might see something like, 10% ethanol. That was largely a product of this legislation where we're trying to not just, we're trying to introduce newer, more renewable, kind of sustainable fuels as part of that. And so there's going to be an increasing amount of renewable components to fuels that are on the market. The last thing I'll talk about is enforcement under Title II. Pretty similar to Title I, similar sort of remedies available to EPA. I'm going to bring up the case of Volkswagen because it got a lot of headlines a few years ago. what happened there was Volkswagen, well, there was a university that did some testing on Volkswagen vehicles, and they were getting unusually high results from its diesel vehicles. And so it was reported to EPA. EPA looked at it further, and what was found was that Volkswagen, and keep in mind, these vehicles are very computerized these days, and they're very sophisticated. EPA had programmed into the computer the engine components that it would be able to recognize when a test was being done, an emissions test was being done, and would go into a different operating mode. And then when the vehicle detected that the testing was no longer being performed, it reverted back to a different operating mode, which had higher emissions. And the reason why it did that was because there were some benefits to being able to claim a higher fuel economy. It's also more fuel efficient, the better selling point. And so this sort of setup was deemed by EPA to be a defeat device. They cheated the test by going into this sort of phantom, this standalone testing only mode, which kind of suppressed the emissions that were recorded from during the test. So Volkswagen was hit very hard. It culminated in a $14 billion settlement. They had a number of other sort of sanctions that were imposed on them, restrictions on how many vehicles it could sell. They had to recall all of its diesel vehicles to fix it. Very costly for Volkswagen. It also culminated in criminal sanctions too. They were charged with conspiracy to defraud the federal government in violating the Clean Air Act. They pleaded guilty, and there was another very substantial criminal penalty that was imposed on top of it. So an example of willful, knowing violations that were egregious enough to rise to the level of criminal sanctions. Criminal sanctions are pretty rare under both Title I and Title II, but they occur every now and then. But it's important to note that if you're advising a facility or representing a facility, you not counsel them to knowingly or willingly violate the Clean Air Act, because there are dire consequences that can come out of that. So that's a very high level overview of the Clean Air Act. You can practice for decades and still, as I said, learn new things about it. But I hope to provide some of the tools that are kind of provided to EPA and other entities under the Clean Air Act statute. And I'm going to turn it over to Jay to talk about some specific issues, namely climate change, and how some of these provisions I talked about have been applied in those contexts.
Thanks, Varun. Yeah, that's exactly right. We have a really good setup now as to kind of how the Clean Air Act works, to then think about how climate change has fit into it, and in some cases not fit into it. So I'm going to request control. Varun, I've also been going through the questions and answers and answering what I can, if you want to hop in there. And I think there will be a little bit of time left at the end here, but it might not be as much as we had anticipated. So feel free to put things in the question and answer, and we'll answer those as we go.
And also the contact information. One of the things ELI has always been great about is telling people, feel free to contact some of the speakers if you have follow-on questions at some point.
Yes, absolutely. I think both Varun and I are happy to take questions if we don't get to yours, but we'll try and answer things in the Q&A there. So good afternoon. As Pam mentioned earlier, my name is Jay Duffy. I am the litigation director at Clean Air Task Force. We're Boston-based, but a global environmental NGO focused particularly on climate change. So I graduated from Villanova Law School in 2010. That was just after the Waxman-Markey bill failed. Its full name was the American Clean Energy and Security Act. And what it would have done is establish an economy-wide cap and trade system. It would have capped greenhouse gas emissions and allowed companies to buy and sell them with a cap that was declining over time. So it passed the House on June 26, 2009 by a really slim margin, but the Republicans in the Senate threatened to filibuster, and the bill never made it to a vote. So this is kind of all happening as I was in school. And with those prospects gone, folks started looking to existing laws to regulate, the ballooning greenhouse gas emissions and, threats of climate change. And as Pam kind of mentioned at the outset, the Clean Air Act is a flexible and broadly written statute that can encompass, emerging problems, different sources of pollution, different pollutants. So I was on the Villanova Environmental Law Journal, and I was reviewing article after article of people trying to figure out, okay, the Waxman-Markey bill failed, now what? Looking at different sections of the Clean Air Act. Should it be a NACS? Should we look at section 115 that Varun mentioned, which is the interboundary international transboundary pollutant regulations? A public nuisance law folks were looking at. So it was a really kind of exciting time, and it's very rare in law, although it's becoming happening more and more often, that we're at kind of the beginning of something, the beginning of an issue. And so it's what I've dedicated my career since then to. I worked on permitting the new infrastructure associated with fracking in Pennsylvania during the Marcellus shale boom at Clean Air Council in Philly after law school, and then made my way over to Clean Air Task Force in 2013, where I've been working for the past 10 years trying to get greenhouse gas emission standards for power plants across the finish line. And more recently, I've been focusing more so on greenhouse gas emission standards for the transportation sector. And I have colleagues who focus on methane emission reductions from the oil and gas sector. All right, so we'll go on to our slides here. There we are. So as a kind of intro here, what we'll be going over, we'll look at the path to the prerequisite finding for regulating pollution under several of the Clean Air Act sections, a finding that the pollution endangers public health and welfare. Then we'll talk briefly about the failed attempt to use public nuisance law to get carbon emission limits on power plants and what that ended up meaning for the Clean Air Act. We'll look at EPA's attempt to fit greenhouse gases into the permitting structure that Varun went over for individual sources, and how that teed up what's called the major questions doctrine that has become very prevalent in climate change law, in things dealing with the pandemic, and has been more top of mind at the Supreme Court lately. Then we'll spend most of the time on these three attempts to set the floor standards, the new and existing standards for power plants for their CO2 emissions under Section 111 of the Clean Air Act. As I said, I kind of thought I'd be able to cover a bit more, but even just this was complicated enough for my full time. All right, so as Pam mentioned, it's really important to get comfortable with these statutes and the relevant sections. That's kind of where it all begins. Sometimes the case law is really exciting, the policies are really exciting, but where it all begins is with these statutes. So as we've discussed, Congress wrote the Clean Air Act and delegated to EPA multiple different jobs in order to ensure that all dangerous pollution, criteria pollutants, hazardous pollutants, ones that don't fit into either of those, as well as a NACS kind of backstop to ensure that air quality is meets public health standards. So that those are all those multiple jobs have been assigned to EPA, and to ensure that we kind of have overlapping provisions to ensure that we have healthy air. So the first attempt to regulate greenhouse gases under the Clean Air Act was started with Section 202A1 of the Act, and this is under Title II that which regulates mobile sources. It instructs the EPA administrator to prescribe standards applicable to emission of, again, and this is the any air pollutant, and what does an air pollutant mean? It means anything, right, as Varun went through, but any air pollutant which causes or contributes to dangerous air pollution. While this particular finding is the prerequisite for standards for vehicles, once that finding is made that greenhouse gases are dangerous and harm public health, it has implications for the rest of for many other sections of the Clean Air Act. All right, so the endangerment finding, I think I am on slide 4, yeah. So on October 20th, 1999, so this is going way back, a group of NGOs petitioned EPA to regulate greenhouse gases under the Section 202. They pointed to mounting evidence of climate change, the contribution of our transportation sector, as well as the ways using the Clean Air Act to regulate the emissions could reduce dangerous pollution. So 4 years later, the EPA in 2003 denied that petition. And they said, you know, we believe that the Clean Air Act doesn't authorize us to regulate greenhouse gases. And they also set forth a number of policy reasons that they thought, you know, either way, it's not appropriate to regulate greenhouse gas emissions under the Clean Air Act. And these reasons included President Bush at the time's policy approach to climate change, which at that time, you know, didn't include Clean Air Act regulation. As well as the, you know, it included other things, but not Clean Air Act regulation, and the international nature of climate change. So they denied that petition, and then several states and others, they challenged this denial. And this ultimately results in the landmark 2007 Massachusetts versus EPA Supreme Court opinion. And so there, the court held that, you know, the Act's broad definition that we've talked about a few times of air pollutant unambiguously covers greenhouse gases. And therefore, EPA is obligated to regulate those emissions if it makes this finding, if it makes the finding that greenhouse gas emissions endanger public health or welfare. The refusal to regulate can't be based on policy considerations. It just has to be a scientific determination. You know, if greenhouse gases endanger public health, then you must regulate according to the Act's instructions. So it was interesting at that time. When EPA denied the petition, the majority of the court, you know, explained as I just did that it is covered by the Clean Air Act and the policy considerations are irrelevant. But the Chief Justice and Justice Scalia and Thomas and Alito at that time, they would have deferred to EPA's policy reasons. They said that, you know, no matter how big of an issue climate change is, you know, Congress passed this really malleable statute, which gives broad discretion, you know, not to a court, but to EPA, and they would defer to the agency. And we'll see as we fast forward, they are no longer, you know, deferring to the agency when it comes to issues associated with climate change in many respects. So the court sends the denial back to the agency to reconsider in light of these new instructions. So then in 2009, the Obama administration finalized the endangerment finding. They concluded that greenhouse gases do indeed endanger public health. And then that decision was upheld by the DC Circuit Court of Appeals in a case called Coalition for Responsible Regulation versus EPA in 2012. The court found that the finding was consistent with Massachusetts versus EPA, and that the text and the structure of the Clean Air Act is adequately and it's adequately supported by the administrative record that EPA put together, all the science and data that they put together, the court found was sufficient. But you can see here, you know, it took a petition in 1999 until a final, 10 years later, the Obama administration finalized the endangerment finding, and then it is upheld in 2012. So these things take significant time, and you know this finding continues to come under attack. Just this past year, I represented clients on the side of EPA fending off additional petitions to reconsider the endangerment finding. The DC Circuit rejected those challenges because none of the challengers had standing. They couldn't show how they were harmed by the endangerment finding. And then also Congress codified Massachusetts versus EPA, that ruling in the Inflation Reduction Act last summer, kind of trying to make it crystal clear that greenhouse gases are covered under the Clean Air Act. So we move on. So now we have this finding that the greenhouse gases endanger public health, but we're not regulating it yet. So how do we figure out how the greenhouse gas regulation fits in with the other provisions of the Clean Air Act? We'll talk about Section 111 standards a little bit later, but they set the floor, and they set the floor for the standards, and 111 also pulls in unregulated existing sources. But once you set that floor of these performance standards under 111, the prevention of significant deterioration permitting program sets source by source standards, not standards for, you know, what's the floor that the whole source category can meet. Then go in, the permitters then go in and look at each particular source and determine what's the best available control technology available for that particular source. And a major source, and this regulates major sources here in this particular instance. A major source is one with the potential to emit either 100 to 250 tons per year of pollutant, depending on the air quality where the source is located. So since EPA found that the greenhouse gases were an air pollutant that endangered public health, they assumed that they were compelled to regulate major sources of that air pollution. The problem, of course, was that greenhouse gas emissions are much more prevalent than other pollutants that are subject to the Act. So regulating every new and modified source of 100 to 250 tons per year of greenhouse gases would pull in tens of thousands of previously unregulated sources into the purview of the Clean Air Act. So EPA tailored the act, and they said they would only regulate sources that emit over 100,000 tons per year of carbon dioxide. So in Utility Air Regulatory Group versus EPA, and this was the first set of briefs I worked on actually when I came over to Clean Air Task Force. There, the Supreme Court determined that the act-wide definition of air pollutant, that was the one relevant in Massachusetts versus EPA, and the endangerment finding provisions, they need not have the same breadth in narrower provisions of the Act, like the permitting provisions. So there was no automatic trigger resulting from the endangerment finding to cover greenhouse gases in the permitting provisions. So in further, the clear language of the Act said 100 to 250 tons per year of pollution, and EPA has no authority to rewrite what Congress wrote. That's kind of basic statutory interpretation 101. You can't cross out 100 to 250 and put in a new number. So the court, in an opinion written by Justice Scalia, they also remarked that EPA's reading of an automatic trigger, you know, as I said, contradicted the plain language of the statute. It was also unreasonable because, and this language comes up over and over again now, because it would bring about an enormous and transformative expansion of EPA's authority without clear congressional authorization. When the agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy, we typically greet its announcement with a measure of skepticism. We, the court, expect Congress to speak clearly if it wishes to assign to an agency a decision of vast political and economic significance. So at the time, we, the folks who have been working on this case, we read this just as commentary that made sense because, reading the act to trigger greenhouse gas regulation in accordance with that 100 to 250 ton per year limit would lead to regulation of tens of thousands of very small sources, laundromats, hotels, residential buildings. But at that time, that all kind of made sense. Yes, this would really expand EPA's scope of jurisdiction, and we want something more clear in a statute if EPA is going to take over, regulating every tiny little source. But as time went on, the case would be cited more and more for this remark than even its primary rationale for rejecting EPA's interpretation, that it directly contradicted with the plain numbers, and it would become kind of the seeds of this new version of the major questions doctrine. So either way, the court did, as far as greenhouse gas regulation, the court did approve of EPA's backup position, and that was that they could regulate greenhouse gases under the PSD section for sources that were already subject to the permitting provisions by virtue of some other pollutant, and they call this the anyway sources. They're covered by these permitting provisions anyway, and therefore we can regulate their greenhouse gas emissions under this section. So I'm going to talk briefly about the public nuisance just because of what it meant for the Clean Air Act. During the same time period, states and trusts and other groups were filing public nuisance claims against major climate polluters. They claimed that the polluters, generally power companies, created a substantial and an unreasonable interference with public rights, and they sought relief in the form of emission limits that the court would write. One of these cases made its way up to the Supreme Court, which said that the Clean Air Act, Section 111, occupied the federal space here, and it preempted the public nuisance claims. It wasn't for the courts to set emission limits, that was EPA's job. So building on Massachusetts, the court held that the Clean Air Act speaks directly to carbon dioxide emissions from defendants' power plants. And under Section 111, Congress delegated that decision of whether and how to regulate carbon dioxide emissions from power plants, and that delegation displaced federal common law. So now we have a clear signal from the court as to the place within which we should be thinking about how to regulate greenhouse gases. So with that signal, the Obama administration set about setting Section 111 standards. So under Section 111B, and this is a little bit of a refresh since Varun covered a bit of this, EPA sets performance standards directly for new and modified sources. Under Section 111D, as in dog, EPA sets emission guidelines for existing sources based on EPA's standard of performance determination. And then the states apply those emission guidelines directly onto the sources. And they can consider the individual plant's remaining useful life and other factors. So Section 111D guidelines can only be set once Section 111B standards are set for new sources in the same category. And Section 111D standards can only be set for pollution that isn't covered by ENACts and is not, and that source, so like power plants, so that pollution is not covered under the hazardous air pollutant standard. So here we have power plants and we have CO2. CO2 is not under the NACs, and it's not regulated for power plants under the hazardous air pollutant sections of the Clean Air Act. So a standard of performance, as Varun mentioned, it reflects the emission limitation achievable by the best system of emission reduction, taking into account costs and other factors that EPA determines has been adequately demonstrated. There are decades of case law defining what reasonable cost is, what adequately demonstrated means, and what it means to be the best system. For the existing sources, the Clean Air Act requires EPA to choose the best system of pollution control, set an emission limit, and then the states have the flexibility to design a plan that is equivalent to the emission limit. They can also take into consideration, as I said, the remaining useful life of the plant, and other factors in setting these individual emission rates for their plants. And they can also decide not to write a plan, and EPA will write a plan for them. So let's get into these kind of three attempts at doing Section 111 standards for the power sector for greenhouse gases. In 2015, EPA set standards for new gas and coal plants. The standards for gas plants was based on minimal efficiency measures and the state of the art at the time. And the standard for new coal plants, of which none were projected. No one was building any new coal plants at the time, but that was based on partial carbon capture and sequestration, could also be met by co-firing with gas. So these rules for the new power plants were challenged, and they were fully briefed at the DC Circuit. But then the Trump administration told the court that it was going to repeal them. It ended up proposing to repeal these standards for new sources, but never finalized it. And that challenge is still sitting in abeyance or on pause at the DC Circuit. What got a lot more attention were the emission guidelines for existing gas and coal-fired power plants. That's the Clean Power Plan. So EPA looked at more traditional pollution controls like co-firing with natural gas or installing these carbon scrubbers, but it found that even if it set standards based on those pollution controls, the sources would meet that standard by just shifting generation to cleaner sources. And that this is how the industry had been reducing emissions most efficiently and most effectively. So that's what the agency based the guidelines on. They called them 3 building blocks. One was efficiency improvements, One was shifting generation away from coal-fired generation to gas-fired generation. And the third building block was shifting generation away from fossil generation toward renewable generation. EPA looked at how much shifting could be done cost effectively and without impacting reliability, and they set the emission limit there. So once that rule was finalized, it was challenged by industry, trade groups, states, and coal interests in the DC Circuit. They sought to pause the rule while the litigation ensued. Pam, I'm getting a little bit of feedback. If there's any way you could mute, it's just I'm getting a reverb of myself back at myself, and as much as I like hearing myself twice, once is enough. There was let's see where I was at. Okay, so once that rule was finalized, it was challenged, and the parties sought to pause the rule while the litigation ensued, but they were denied by the DC Circuit. They then sought relief from the Supreme Court, and which asked them to, and they asked the Supreme Court to stay the rule. That briefing was done over a matter of days and nights, I can attest to, and on the shadow docket with no explanation. It was actually Justice Scalia's final action before he passed away. They stayed the effectiveness of the Clean Power Plan for the duration of the court proceedings, and it never went into effect and won't. The case then was fully briefed at the DC Circuit. Oral argument was held before a full court, including then Judge Kavanaugh on the DC Circuit. That was in September 2016, but the court never issued an opinion because the Trump administration disavowed the Clean Power Plan once they came into office. So then 2 years went by before the Trump administration, EPA repealed the Clean Power Plan based on its interpretation of the Clean Air Act, that only systems that can be considered for the basis of performance standards are those that can be applied to or at an individual source, and that this kind of generation shifting was not, a kind of bolt on to or at the individual source system. They also, as kind of a backup argument, said that the Clean Power Plan exceeded EPA's authority under the Major Questions Doctrine, which they understood to preclude, any costs, really expensive or politically important rule unless the rule was clearly authorized by the Act. The Act, however, has broad language, as we've discussed, kind of applicable to multiple pollutants and to sources, so it doesn't specify or authorize any particular systems. To replace the Clean Power Plan, EPA issued the Affordable Clean Energy Rule, or ACE, and that provided states with a list of efficiency improvements that states could evaluate to set emission limits for the plants within their states. So environmental groups, some power companies, and states challenged the rule as too weak, noting that by kind of investing in these coal plants and making them more efficient, they would likely run and pollute more and longer, and that there were better systems of pollution control available. And they also pressed that ACE impermissibly failed to set, kind of a binding emission limit. It just gave states options. Coal interests also challenged the rule, and they argued kind of from the other end that greenhouse gases from power plants don't contribute enough pollution to endanger public health and the environment. And you can see kind of, again, this is our argument that the Clean Air Act doesn't cover greenhouse gases. And they also argued that because power plants were already regulated for their hazardous air pollutants, they couldn't be regulated under another provision for their climate pollution. So on the last day of the Trump administration, the DC Circuit issued an opinion finding that EPA can regulate greenhouse gas from power plants, that the determination that greenhouse gases from power plants significantly contributes to endangerment was proper, that the statute does allow EPA to regulate both hazardous pollutants and greenhouse gases from one source under different provisions, and that the finding that the rule was and they found that the rule was indeed too weak because it didn't have binding emission limits. And it rejected EPA's reading that the system must be applied to or at an individual source. They couldn't find that in the plain language of the Act. And then relying on the AEP versus Connecticut, that public nuisance suit, they found that EPA's greenhouse gas regulation from power plants under Section 111 is clearly authorized by Congress, and therefore there isn't a major questions problem. So this was appealed to the Supreme Court. And in a decision last June, the court confirmed that EPA does indeed have authority to regulate greenhouse gas emissions from power plants under Section 111, and that EPA must set a binding emission limit. And it didn't opine on whether a system must be applied to or at an individual source, but it did find that standards based on shifting generation away from the source category isn't authorized by Congress, and that violates the major questions doctrine. So this was the first time that the court kind of formally announced the major questions doctrine. Since the 90s, there's been seeds of it in there and different flavors of it, but this was the first time they recognized it by name. And they said, that their precedent taught them that there are extraordinary cases that call for a different approach to statutory interpretation. These are the cases in which, the history and the breadth of authority that the agency has asserted, the economic and political significance of that assertion, provide a reason to hesitate before concluding that Congress meant to confer sort of great authority. So in these certain extraordinary cases, separation of powers principles and understanding what Congress might have meant made them reluctant to read into kind of this broad language that the Clean Air Act has, a delegation for more power, and in order to convince them otherwise, something more than just broad language needs to be pointed to. There must be clear congressional authorization for the power that the agency claims. The court said that it couldn't locate clear authorization to base standards on shifting generation, and therefore that the Trump administration properly repealed the Clean Power Plan. That was last June. And so now we're looking forward, right? So we're in thinking about how to go about regulating power plant climate pollution under Section 111. West Virginia provides some guideposts. The court was clear that standards can't be based on shifting generation from these covered power plants to uncovered sources like renewables or other generation sources. They spoke more favorably of the traditional end of the stack at the source pollution controls that cause the covered plants to operate more cleanly. They were clear that once an emission limit is set based on an appropriate system, then the states and the plants can comply in any way they see fit, including by shifting generation. They said there's clearly a difference between setting the standard on generation shifting versus setting a standard based on kind of traditional pollution controls, and then the plant deciding that, now that it's being forced to internalize its cost of pollution, they may decide to shift toward cleaner generation with lower costs. So that is permissible, but basing the standard on shifting is not permissible. So this is a lot, and I won't go through all of it, but I wanted to give folks a flavor of where we are now. On May 23rd of this year, EPA proposed a new set of standards for the fossil fleet. They are accepting comments on the proposal until August 8th, about a month away. I have been vigorously writing with my colleagues, and they're aiming to finalize the rule by the end of April 2024. So EPA has authority to subcategorize, and this is across the statute. They can subcategorize based on size, class, and type of source, and they use that authority really extensively in this proposed rulemaking to break the fleet into categories based upon what role the power plants are playing in the power sector. They're also providing very long timelines to allow for planning and permitting and building out infrastructure. So for new coal plants, EPA proposes to leave those 2015 standards in place, those ones that have been sitting in the DC circuit for years. They've been in place for 8 years now, and they're based on partial capture, partial CCS. And for new gas plants, EPA divides the fleet into 3 categories based on how much the plants are operating. Are they at low load, intermediate load, or base load? How often are they running? 20% of the time, 50% of the time, et cetera. And for some categories, they provide time to ramp up to the full best system standards. So those are the phases you see across the top. For those peakers that are only running 20% of the time or less, they must stay below that threshold and use lower emitting fuels. For the intermediate load, before 2032, they just have an efficiency standard based on simple cycle turbines. But this, then in 2032, the plants will have a tighter standard based on 30% co-firing with low greenhouse gas hydrogen. They are tailoring low GHG hydrogen to tax credits found in the Inflation Reduction Act that was passed last year. And there's a tax credit called 45V that incentivizes use of cleaner technologies, cleaner hydrogen. There's several actually tax credits that are relevant here. There's others for that provide credits for carbon capture and sequestration as well. So I'll move on to new baseload gas plants. The first phase, it will be based on efficiency. And after that, EPA is proposing two pathways, one for CCS and one for hydrogen. For hydrogen, the plant will co-fire with 30% hydrogen starting in 2032, and then ramp up to 96% in 2038. And for the CCS pathway, the plant would need to meet a standard based on 90% CCS in 2035. So just to give you a flavor of kind of what EPA is trying to do, which is to kind of tailor the standards to how these plants are operating and really focus on those traditional at the source stacks and give long lead times. For existing plants, again, the EPA is dividing the fleet for coal plants. They're dividing the fleet based on when the plant commits to retire. Those that plan to retire before 2032, they just have to maintain their rate. A plant that commits to retire by 2035 and run less than 20% also can keep its emission rate. And a plant retiring before 2040, but not falling into one of these two subcategories, their system of emission reduction, their standard is based on 40% co-firing of natural gas. And if you're operating past 2040, the standard is based on 90% carbon capture. The middle column is a really tiny fleet, so I'm going to skip over that one. And for existing gas, the proposal would cover units that are larger than 300 megawatts. So they're not covering the entire existing gas fleet. They're taking kind of a stepwise approach here. But so they're just covering with a CCS-based standard those plants that are larger, those units that are larger than 300 megawatts and run more than 50% of the time. And they're taking comment on lower pieces there. And then if for those plants, there is again that CCS or hydrogen pathway if they're covered. So that is all for me. Sorry for the rapid fire, but I wanted to cover all this. I can go into some questions, or I will throw it back to Pam to MC us as to how we'd like to spend our last 10 to 12 minutes here. No, you're on mute, Pam. And yes, I'm looking at a question here. The endangerment finding regarding greenhouse gas emissions from power plants is definitely viable after West Virginia. It says in the opinion that greenhouse gases are covered. They only took issue with how EPA was regulating the greenhouse gas emissions, not that they were doing it.
Well, what I was saying when I was muted was that you did a superb job, because the prognostication piece is the toughest. You know, a lot of us have talked about what the Clean Air Act provided before, and then you gave us one of the best explanations of where we're going in a very tricky area. So
thank you.
So let's see. We do have a few questions. Let me see if there's anything specifically related to climate in there. Is captured GHG a hazardous waste? I mean, is that?
No, it is not. Captured CO2 is not defined as a hazardous waste. There are a lot of provisions under the Safe Drinking Water Act that ensure that when CO2 is sequestered underground, that it's done so safely. So there is a lot of there's that, and then there for any emissions from those wells, there's a portion of the Clean Air Act, the greenhouse gas reporting rule, that has monitoring and reporting and verification requirements to ensure that that the CO2 that's captured is not leaking from the sequestration sites.
Jay, since as you well know, CO2 is only one of the greenhouse gases, would you comment on what the future is, especially for methane, which I think everybody recognizes is vastly more potent than CO2 in terms of climate?
Yeah, that's
some of
right.
the other, some of the other GHGs also.
Right. There's also an effort right now to regulate HFCs, which are very potent as well. But this EPA is doing a great job of oil and gas methane emissions associated with the fracking and compressors and pipelines. And I think in order for gas to have any sort of bridge fuel properties in the power sector, it needs to be upstream emissions need to be cleaned up, or it doesn't make much sense to burn it at a power plant if it's just leaking and causing greenhouse gas climate problems elsewhere. So these one of the issues with the Clean Air Act is it doesn't have a lot of wiggle room for life cycle emissions. It really regulates kind of the emissions at the sources, at the vehicle, at the power plant, at the well, whatever it is, whatever that point source is. And so we have this issue with biomass. Biomass increases emissions at the stack, and so that is all that is kind of seen from the Clean Air Act's perspective. Hydrogen, right? Hydrogen reduces emissions at power plant stacks, but there's a lot of emissions associated with generating hydrogen. So I do think that the Clean Air Act can do a lot, but it was very much focused on how do we clean up the emissions from particular sources. And now we're looking at a lot of different fuels and things like that. Maybe it will be able to regulate those with some more creative thinking, but those life cycle emissions can be tough.
Well, I know there hasn't been the stomach to try to amend the Clean Air Act in any significant way. People are sort of afraid of what you asked for. And so I think that it probably will not be amended, but I would like each of you to give me a prognostication. 1 year from now, what do you think would be the major change or addition to what we're doing to regulate either conventional pollutants or GHGs?
I guess I'll go first. I think the big one is, I think you hit on it, Pam, is revision to the NACs to include a greenhouse gases of some sort, be it carbon dioxide or methane or something. And I think that's going to be it's going to have a lot of shockwaves associated with it, because as you mentioned, Pam, those criteria pollutants have been the same since their outset from the outset. So that's going to be something I think that's it would not surprise me and I think that's where we're going next with the next big thing in the Clean Air Act. There's definitely going to be all kinds of litigation over that. And, the thing to note with the Clean Air Act is, as I think some of the issues pointed out by Jay reflect, there's a lot of political whiplash over it, even if the statute itself is not changed. But, certainly from administration to administration, with power plants and carbon dioxide emissions from them, we had clean power plan, affordable clean energy, the Biden rule. It's just, I think we're going to see something like that for the next 5 years or 10 years or beyond. But again, if I had to hazard a guess, I think revision to the NACs is going to be the one that really gets people's attention.
How about you, Jay? What do you predict?
Well, I think
big one to watch.
Right. I think one of the most interesting things to me is kind of not what the impacts of the Inflation Reduction Act are to how we use all of these provisions. The Inflation Reduction Act is the biggest investment in clean energy that we've ever had. And so now we have a kind of turbocharged build out of hydrogen hubs and pipelines. There's investments for CCS, there's investments in renewable. So there's investments in EVs. So there's a lot is changing very quickly. And so by using the statute, we can leverage kind of the Clean Air Act is forward-looking, it's technology forcing. And so when we are having such a quickly advancing clean energy economy, and the Clean Air Act is meant to kind of push the envelope and keep things going, I think we can just have much stronger rules. So I'm interested in kind of how this big influx of investment pairs with these instructions that Congress gave EPA to push pollution control forward.
Well, my prediction of something to watch out for is the strengthening or tightening of the secondary standards. Those really haven't been touched in a long time. And as you know, the criteria to be used by EPA are mushier. It's, protection of welfare. And so that's been never been taken really seriously. And as you know, there's a push to get EPA to really do something with secondary standards, which would give a lot more tools to EPA, because again, it wouldn't be simply constrained by the science and protection of human health, but it would be to protect welfare with all of the attendant issues that brings, including obviously EJ and other things. So I just think that is a tool that hasn't been used sufficiently in the past. They could open up a lot of tightening of operations, and certainly a lot of litigation. Does anybody else have any questions or any final thoughts? I mean, like I said at the beginning, I think, and I'm biased, the Clean Air Act is one of the most elastic and fabulous statutes. And air, unlike water or a waste site, doesn't have boundaries in the same way. So that's what has allowed it to be used so expansively. And again, I mean, I encourage everybody who's been listening to this webinar to dig into this great statute and to consider working in the airfield, because it's not going to go away. You have job security if you're an air lawyer. So anyway.
It's true. I hope I can finally get one of these rules across the finish line.
Oh, my money's on you. So anyway, thanks to both of you and to ELI. And as I said, for those of you listening, just reach out to us if you have any follow-up questions at any point, and good luck. And I also want to give a little plug to the ELI boot camps, because to those of you who have not ever attended those, it's a marvelous opportunity. In a week, they have one on the East Coast and one on the West Coast, and you get a grounding in all of the basic statutes. And so it allows you to really compare and contrast. So you would get a presentation like this, really a little longer, and then see the Clean Water Act and see RCRA and see CERCLA. And it's as I said, I think the boot camp is a very, very useful opportunity to showcase all the similarities and the differences among the various environmental statutes.
Thank you all.
Thank
you
you
so much, Pam, Jay, and Varun, for speaking at today's program. We so appreciate your time and your efforts to educate our audience on environmental law. I think Varun mentioned earlier that the Clean Air Act is just particularly complex. Law schools offer entire courses on the Clean Air Act. So we really appreciate you all taking the time to cover it so succinctly and explaining it so well to our audience. So thank you again. And please join us back to our audience. Please join us at 12 p.m. Eastern on the remaining Thursdays throughout the rest of July. Coming up next, we have our climate change session taking place a week from today on Zoom. And please remember to register on eli.org. Thank you all again and have a great day.
Thank you.